Hey guys, my name is Ryan Nerney, and I'm a managing partner at the nationally recognized security clearance, military, and federal employment law firm Tully Rinckey. Welcome to the 7th episode of the podcast for the National Security Clearance Lawyers Association. This is the very first podcast made to teach people from all industries that require security clearance the ins and outs of the security clearance process, what the adjudicative bodies look for in potential disqualifying and mitigating conditions, and what potential and common situations mean for your security clearance. So whether you're an employee for a government contractor, a federal employee, or a member of the military, you're sure to pick up some tidbits of useful information when you listen to the NSLA podcast. In today's episode, we are joined by Senior Associate Brittany Forrester, who has a plethora of experience in litigating security clearance cases. So Brittany, why don't you tell us a little bit about yourself and your experience?
Thanks, Ryan. Good afternoon. Yes, I'm a Senior Associate here at Tully Rinckey. I practice in our security clearance and federal employment practice groups. I've handled security clearance matters for a number of years from various stages, from filling out the SF-86 all the way through responding to a statement of reasons, attending a hearing, and also the appeal phase. So a plethora of knowledge in all the guidelines and working with multiple different agencies and military for security clearance purposes.
Thanks, Brittany. So today we are going to continue our series where we talk about the specific adjudicative guidelines for security clearances. We previously spoke about Guideline A, B, C, D, and F. However, today we're speaking about Guideline E, personal conduct, which is essentially the catch-all adjudicative guideline. So anything that the government can't really get you on, or they're not sure where to put you, or your allegations, they'll throw you into the Guideline E. So by the end of this episode, you'll have a general understanding regarding what adjudicators typically look for regarding Guideline E cases and the disqualifying and mitigating conditions for this particular guideline. So if you tuned in for either of our last 6 episodes, you learned that any adjudicator focuses review on the 13 adjudicative guidelines disclosed in the Security Executive Agent Directive 4, which is pursuant to the Executive Order 12968, which consists of guidelines A through M. So as I mentioned before, today we're going to talk about Guideline E, which is probably, I would say, the most common guideline alleged across all government agencies, because again, it essentially encompasses any concerns not captured in other guidelines, and also deals a lot with allegations involving lack of candor, trustworthiness, omitting facts, things along those lines. So Guideline E relates to personal conduct, as I said before. The most common thing we see is omitting or falsifying material information on your security clearance application or during any investigation. Or a combination of allegations pursuant to another guideline that was alleged in a statement of reasons. However, personal conduct also less frequently encompasses criminal conduct, failure to comply with an investigation or impeding an investigation, falsifying other documents outside of the security clearance investigation, things of that nature. So while Guideline E is one of the most common guidelines we see, contrary to Guideline F, as we discussed in the last episode, it's always one of the more it's also one of the more complicated guidelines, given it encompasses a wide variety of allegations. So, Brittany, why don't we discuss a little bit about the disqualifying conditions and kind of what those are and what typically triggers the Guideline E disqualifying conditions.
All right. So under Guideline E, there are 7 disqualifying conditions. Ryan mentioned a couple of them, which is omitting or falsifying information on the security clearance application or during the interview with the investigator. But there are other avenues that the government looks at as far as falsifications. Those could include a statement made to a mental health provider when they're doing evaluation related to a security clearance eligibility determination, financial affidavits and things like that, where there could be misrepresentation of submitted documents. It also looks at information and events that could be considered or not considered falling within another guideline, but could be questionable to your judgment, your candor, your willingness to comply with laws. Where that comes in is any pattern and practice of past criminal activity, past workplace incidents. A big place where this comes up is when you're reporting in your employment section. It's important to give the accurate reason for any termination or any reason that you've left, because when they undergo the interviews of those employers, a lot of times if they find out information, that's another way that it can lead to a Guideline E's finding information through the interviews with your employers, the people that you've listed as references and such as that, and also any involvement in criminal activity. And it's common for the government to throw in Guideline E as it relates to other guidelines as well. So not only a sole Guideline E case, they can put it together with other guidelines in a statement of reasons.
Yeah, we commonly see that, right, Brittany? So, like, if there's somebody did drugs or smoked marijuana, right? They typically throw a Guideline E in there as well, as far as criminal conduct, or sometimes, like you said, it kind of gets roped in there if they didn't even disclose the marijuana use on their SF-86 or security clearance application. You see that a lot, right?
Yeah, and they do it with almost every guideline. Anything that could be calling your judgment, your responsibility, trustworthiness into question, they will pose it as a Guideline E concern.
Yeah, and sometimes, obviously, if they don't know what guideline to put you in, they'll just throw the Guideline E out there because like I said at the beginning, this is a catch-all guideline. So. Brittany, obviously she went over the disqualifying conditions, but if you've been listening to these episodes, you obviously know there's mitigating conditions as well that I'll kind of go over. So just like the disqualifying conditions, there are 7 mitigating conditions applicable to Guideline E as well. It obviously depends on the circumstances on when these come into play, but one of the things is the individual made a prompt or good faith effort to correct the omission, concealment, or falsification. And the key to this is before being confronted with the facts. So we see this a lot where, like Brittany and I were just discussing, where individuals leave information off of an SF-86 or security clearance application, whether intentionally or not. And one of the best ways to kind of mitigate that is to correct that omission, admit to it, provide some reasoning behind it, but doing that before anybody brings that to your attention. So, if you leave it off your SF-86, you have your supplemental investigation with an investigator. If you provide that information initially to the investigator before they bring it up to you, that will kind of be addressing this mitigating condition. Another one is, if you were provided some sort of advice by somebody who's familiar with the security clearance process, to leave something off, or maybe even sometimes I see this a lot where, there's a criminal record and somebody doesn't report it because their criminal attorney said, hey, this is expunged, you don't need to report it at all. Now, obviously, that individual would have relied on that advice from that attorney, but, it comes into play if that attorney actually has experience with security clearance matters. So, that's something to take into account as well. But they do look at, if you received advice in order to, leave that off. Sometimes, Brittany, I'm sure you've probably seen this as well. Sometimes you see, individuals trying to get into the military, and the recruiters say, hey, you smoke weed, leave that off. Otherwise, you're not going to get in. That's a big no-no. It doesn't necessarily bite them in the butt initially, but it could come back to bite them, later on down the line, which, I'm sure you've probably seen, but, I see quite often, where individuals, left things off because the recruiter told them to, and now they're, at their 3rd or 4th or 5th SF-86, and, now they're worried about that coming out or, what have you. So, it's a big issue. Is that something that you've seen before as well?
Absolutely. And, piggybacking off of that, it's important to complete the SF-86 and avoid these Guideline E potential concerns, because the earlier the better. Speaking to later down the road when you're on the 5th and 6th SF-86, but more importantly, if you ever decide to go for a higher level clearance that may result in a polygraph, that is a very common question, is to look into whether you've ever falsified or misrepresented information on a past security clearance application, and that would be something that would pose a problem under polygraph if you had in fact done so. So it's important to get ahead of all these potential concerns ahead of time and properly report and be honest and truthful in the investigation process. Yeah,
absolutely. So obviously those are 2 of the main mitigating conditions. There's also, I kind of call this the catch-all mitigating condition as well. The offense is so minor, so much time has passed, the behavior is infrequent, unique circumstances, things like that. That's kind of the catch-all mitigating condition as well, that honestly can be applied to pretty much any scenario. The individual acknowledge the behavior and obtain counseling to change that behavior. Sometimes you can do, behavior modification. Sometimes, there's circumstances that, with mental health that kind of led to some of the Guideline E behaviors. So if you're getting help with those circumstances, that mitigating condition would come into play as well. The individual has taken positive steps to reduce or eliminate vulnerability. That one, is kind of a unique circumstance, but I mean, it could be, any positive steps that you've taken. So if you've done any type of additional training, if you have, changed the way that, I don't know, maybe you handle classified material, or, you don't put yourself in certain environments, things like that, that could be considered taking those positive steps. The next one, obviously, information was unsubstantiated or from a source of questionable reliability. This is something you can argue if, somebody lies or somebody, knows somebody is kind of stretching the truth, if you will, to kind of elicit this Guideline E allegation. Sometimes what I see is if somebody's going through divorce and the ex-wife is, it's obviously a tumultuous divorce, the ex-wife makes some sort of, or ex-husband makes some sort of, derogatory comment or statement that, this person did this or this person did that. Sometimes that could elicit some, Guideline E allegations. But if you're able to show that, that person who made that allegation had, questionable reliability, they've lied previously, or there was an investigation, it was unsubstantiated, you can kind of make those types of things or arguments. And then the final one is obviously association with persons involving criminal activities. It was unwitting, it stopped, occurs under unique circumstances. That's something that you can typically use if they kind of throw the Guideline E in conjunction with the Guideline J, which is criminal conduct. So that's kind of where that mitigating condition comes into play. But, obviously everything is looked at on a case-by-case basis. These are just the general guidelines that we see and mitigating conditions that we see. But moving on to the next aspect here, obviously we spoke about, Brittany, the disqualifying conditions, right? But what are the general issues that you typically see when you're handling these security clearance cases that typically elicit a Guideline E concern?
So a lot, outside of initially filling out the SF-86 and undergoing the interview, a lot of times that this comes up uniquely throughout the process of maintaining classified material is when something comes up, like, for example, you've been granted your clearance, maybe you unintentionally ingest marijuana and you don't report it in a very timely fashion. That has resulted in a Guideline E where the government's found out about it, or you later self-reported it and it's been months since the actual incident. That calls into question your trustworthiness and reliability as well, as far as how soon after you've discovered that you made a mistake on the SF-86 or you made a mistake during the interview, or again, you've already had your clearance granted and something new happens that you need to report. It's important to do so as soon as possible, because that is another issue that raises concern regarding your conduct and potentially lack of candor.
Yeah, absolutely. And, that's the biggest thing for Guideline E, right, is the lack of candor aspect, because ultimately when somebody's, getting vetted for security clearance, they look at, key components and key characteristics, which are honesty, trustworthiness, reliability, good judgment, things like that. And obviously, if you're lying or, you're omitting some material information that is needed in order to properly adjudicate a clearance, that's going to call into question those characteristics. So that's why, as Brittany said, those Guideline E concerns typically, are present in those types of cases. So, and then, one thing I want to kind of go over just to give, our listeners some insight, maybe as far as some common cases that we see are, some cases that potentially we've handled in the past that, may provide a little bit of insight, for our listeners on what, potentially a Guideline E allegation could look like in the quote unquote real world, right? So, specifically for me, I've had a recent case, to be honest, where individual had, used illegal drugs, and they were essentially scared to list it on their SF-86 for one reason or another, and they left it off. And they did not report the drug use, which was within the reportable 7-year time frame. And, we ended up submitting a written response and going to a hearing in this case. And, one of the main things that we argued is to fall on your sword, right? A lot of times these judges or these adjudicators who are looking at these cases, they want you to accept responsibility for what you did and then show why this won't happen again. So in this particular case, that's exactly what happened. We were able to, obviously they accepted responsibility for what they did. They learned from their mistake. It hadn't happened for a number of years. Specifically talking about the Guideline E aspect of this. And they also, took various different online courses and kind of changed their attitude, if you will, to kind of show the judge why this wouldn't happen again. And ultimately, we were able to get a favorable outcome in that case. So that's just kind of one real world scenario. Obviously, I just want to put a caveat out here that, however, every case is looked at individually. So simply doing, like I said, every case is looked at individually. So, just because this happened in this case or this happened in this case, whether positive or negative, doesn't necessarily mean that that's going to be your case. Now, there are obviously the adjudicative guidelines that are followed here, so we can get a general gist of what particular judges or adjudicators are looking for, and obviously make those solid arguments there. But, just want to put that caveat out there that obviously each case is looked at individually. But, Brittany, obviously you do a lot of these cases as well. So, what have you personally seen, in a case that you've handled particularly with a Guideline E allegation?
Yeah, absolutely. I've handled several, and this one, goes to show how, I guess, quote unquote, nitpicky the government can be. So I recently handled a case where an individual had completed a pre-employment checklist, if you will, and it asked questions regarding mental health diagnosis. And the employee had unintentionally overlooked some of the check boxes in the form, but listed that they had a VA disability rating. And upon request from the government, they properly provided all the VA disability documents. It showed the diagnosis. It was, in his opinion, open, honest, and forthcoming, and just made a mistake on that form. Yet, lo and behold, the government still issued a statement of reasons, intent to deny the clearance under Guideline E, saying that he misrepresented the mental health diagnosis on the form. And of course, we were able to utilize the mitigating conditions and show that it was an honest mistake and that there was no intent to mislead the government or conceal information. And we were successful and favorable in that case.
Awesome. And that's the key, right? So the intent or the deliberate action, right? So you have a little bit of a stronger argument if, it was just a simple mistake, and you didn't really have that intent or, the deliberate, action to try and deceive the government. So that's a good point to make. Absolutely. And that's obviously a real world case. Obviously Brittany and myself handle these all the time, so we can kind of give a little bit of insight there. But again, I just want to reiterate, each case is looked at individually. So if you're not certain, you can do your own research or, you can, contact somebody for some assistance. But, overall, these are obviously serious circumstances that, everybody who needs a clearance, has to go through this vetting process. Submitting the SF-86 and, things like that. To give you a little bit more insight, you can go to one of our first episodes where we kind of go through that. But that's kind of what you can expect for Guideline E, cases and allegations. So there you have it for this month's NSLA podcast. Special thank you to Brittany Forrester for being a guest today and kind of giving her insight based upon her experience and what she's seen in regards to this guideline. So please keep a lookout for more content to assist with your current and future security clearance journeys. Thank you for listening, and we look forward to you joining us next time. Also, one more aspect, we are now on Apple Podcasts, so keep a lookout for future episodes on that platform. Thank you.